Hi, everyone. Welcome to the Heart of New York show. I tell you, today is going to be probably the first time you ever heard me speak highly of an attorney. And I'm going to tell you why. Because there was a time in our life that we needed one, okay? And at that same day that we needed one, here appears Elizabeth Forspan. Now, over the time that we needed her on the case that we had, she did everything incredibly superb, and the timing was perfect, and the outcome could not have come any better. Because what I'm about to talk to you about today is you got to really pay very, very close attention to this, because this could help your family in time of need, because we're going to talk about some very important issues here. And this is Elizabeth Forspan. Okay, she's a partner at Forspan Clear, LLP, a New York-based law firm. Her practices focuses on elder law, trusts, and estates, and taxation. A recognized authority in her field, Elizabeth lectures across the United States on topics related to elder care planning, estate planning, and tax law. She's a recipient of the Max Block Award for Outstanding Article and Technical Analysis presented by the CPA Journal of the New York State Society of Certified Public Accountants. Elizabeth has also been named a super lawyer, not just by me, annually for the past 10 consecutive years. And I kid you not, her insights have been featured in New York Magazine and Market Watch, and she has been quoted in the New York Times. Her written book has appeared in the New York Law Journal. Before co-founding Forspan Clear, LLP, Elizabeth served as a tax manager at Ernst & Young LLP, specializing in mergers and acquisitions and executive compensation. She covers all bases. She earned her Juris Doctorate from Fordham University School of Law and holds a BA from Queens College, City University of New York, where she graduated summa cum laude and was inducted into the Phi Beta Kappa. Elizabeth is actively involved in community service and currently serves on the boards of several nonprofit organizations. She is also the president-elect of the Brandeis Association, Queens County Jewish Lawyers Bar Association. Welcome. I mean, listen, I can go on and on and on, but this person, and we got a real good close time clock right here, and I want to make sure I covered all bases, because what you're going to hear is so extremely important. I want to get into first a lot of topics here, but number one, let's go into long-term care. For those of us that's looking into the future, thinking about the care we may need, what are the options available for the people out there to pay for care?
Peter, thank you so much for that incredible introduction. Very much not deserved, but I appreciate it. So I love this question. When we think about long-term care, what are we thinking about? We are thinking about as we age and we may need care at home or maybe in an assisted living facility or perhaps in a nursing home. We have to think about how we are going to pay for that care. How are our loved ones going to be paying for that care? And there are a number of options. Some people pay privately. They've accumulated assets during the course of their lifetimes, and they will use those assets as they age to pay for care. But of course, care is extremely expensive. Care is extremely expensive. For example, in New York City, a nursing home could cost upwards of $17,000 or $18,000 per month. That's a lot. And home care, to have an aide, a home health attendant take care of you at home, can be upwards of $40 an hour, sometimes $50 an hour. So some people who are blessed have those funds and have the ability to pay privately, but most people don't. There are other people that planned ahead, way in advance, and they acquired what's called long-term care insurance. Long-term care insurance is wonderful. That's an insurance policy that you purchase when you're a little younger and healthier, and it is for when you get older If you're going to need nursing home care, or perhaps assisted living care, it would pay for that. And then there are others who avail themselves of government benefits. And
You're
so,
talking about Medicaid, right?
Medicaid,
Okay.
exactly. So the reality is that many people do not have long-term care insurance and don't have the ability to purchase it now. The reason is because they're older when they start thinking about this, and they can't pass the medical underwriting or the medical testing that is required for you to become qualified for long-term care insurance. And so long-term care insurance for a lot of people is not an option. And even those who have long-term care insurance, sometimes the benefit that they have could be, let's say, $125 a day or $150 a day. And we know a nursing home, especially in this area, can cost upwards of $600 a day. So for some of those people that do have long-term care insurance, it's just not an option. It's not going to cover enough of the care. And then when we talk about private pay, many people just don't have those funds to cover the cost of private pay. Or in the case of a couple, you'll have a situation where one member of the couple gets sick, and we don't necessarily want to deplete all of the couple's assets to pay for the sick spouse's care, because then there's going to be nothing left to pay for the care of the quote-unquote healthy spouse when he or she needs the care. So many people avail themselves or choose to avail themselves of the Medicaid program. Now, in order to qualify for Medicaid, we have to do some advanced planning, because Medicaid was originally designed as a program for the indigent. But of course, there are many people that are on Medicaid now that weren't necessarily indigent, but they did planning far enough in advance that they were able to qualify for it and have the government pay for some of their care.
Excellent. And that's very important for people that don't have the funds to pay for itself, which is $17,000 a month plus. But it takes extensive work, pre-planning before, so these bases are covered. And this is what she does, and she does it meticulously, and it worked tremendously for us. I want to get into estate planning and elder care. What do we mean when we say estate planning?
So that's a wonderful question, because estate planning and elder care go hand in hand. You cannot do one without the other. So when we talk about planning for the eventuality that someone is going to need Medicaid or elder care planning, what we're talking about is possibly creating a trust or divesting yourself of certain assets so that after a period of time, you will be able to qualify for Medicaid. But when we do this planning, it is critical that we keep an eye on all of the estate planning considerations. For example, if we are going to divest ourselves of assets by giving those assets away to, say, one of our children, we have to say to ourselves, well, what about the other children? What happens when I die? I've given away assets so that I could qualify for maybe Medicaid. I gave it to one child for whatever reason, but when I die, what happens to the other children? How do we equalize that? Another thing that we need to keep very close attention to are the tax considerations in elder care planning. When we do elder care planning, we want to do it in a way where we consider all the possible tax implications. For example, when we give away assets, we want to make sure that when we die, we will obtain, or those assets will obtain, what's called a basis step-up. That will help us reduce capital gains taxes or potentially eliminate them entirely for our children when they later sell the assets. So it's very important that when we do the Medicaid planning or the elder care planning, we look at the tax implications and how those will be impacted. Unfortunately, some people will engage in the elder care planning or the Medicaid planning divest themselves of assets, but do it in a way that is very tax inefficient. And that could yield a very negative result. So when we do our elder care planning, we want to look at our estate planning and our tax planning.
This sounds really, to some of you out there, it sounds complicated, but let me tell you, she's got it down to a science. It's not, and it's done quickly, efficiently, and right to the point on each step to take, because this is very important. You got to follow each step, and the timing has to work out in situations like this, as it did for my family and me, and it was awesome. At what age? Here's the key. You got so many people that are going to watch this saying, "Oh boy, my parents, they're up there, they're ready to go." So, when are they going to start about thinking? When should they start and get a jump on this, thinking about elder care planning?
Peter, I love this question. It's almost never too early to plan, but sometimes it is. So if we're thinking about long-term care insurance and not thinking about necessarily availing ourselves of Medicaid, I would say that when you are young and healthy and can qualify for the insurance, that is the time to obtain the insurance. For example, this may sound a little nutty to you, but I obtained a long-term care insurance policy when I was 34 years old. Just a few minutes ago. Just kidding. So I obtained a long-term care insurance policy when I was 34 years old. The reason why I did it was because I practice in this area and I see what can happen. Now, that may sound very early, and it is. And with God's help, we should all be healthy for a very long time. So if we're thinking about long-term care insurance and we're in our 50s or 60s, look into it, call someone who can help you, an honest broker who can help you look into that.
Now, you said you started when you were in 30-something.
Mm-hmm.
Okay.
That's right.
How about people can? If they're like 50 or 60, is it too late for them?
So it may be, right? If they have a certain health concern, it might be too late for them to obtain long-term care insurance. Mm-hmm. However, if an individual cannot obtain long-term care insurance or doesn't have the funds to obtain long-term care insurance, and they want to start thinking about Medicaid planning, then what they should do is, in general, now there can never be a general rule that applies across the board because everyone's situation is different. But in general, I would say that the proper age to start planning is about 65, in our mid to late 60s. And the reason for that is because there's something called a 5-year look back. It's not that we can divest ourselves of our assets today and qualify for Medicaid tomorrow, particularly in New York when it comes to institutional or nursing home Medicaid. We need to think of this planning in advance. We need to have 5 years between divesting ourselves of our assets or putting our assets in a trust and then applying for Medicaid. So statistically, if an individual starts that planning when they are in their mid-60s, statistically they will have 5 healthy years. Of course, that doesn't apply to everyone, and if there is a health concern, or if you think that there might be a real health concern, perhaps you should start the planning a little bit earlier than your mid-60s.
Now, when we started this, I said, "Oh my Lord, how am I going to get everything together and find out what is it that's there, and how do the next step?" So what I'm saying is, can you tell them out there what are some of the most important documents or things that they should get together to start this process?
Absolutely. So what I would say is that everybody, first of all, should have a good handle on their assets and their income. But one of the most important things that people need to get in place early, very early, is a power of attorney. A power of attorney is probably the single most important planning document that an individual could have. A power of attorney is where you appoint someone else to make financial and legal decisions for you, in case you can't make those decisions for yourself. So for example, I can appoint Peter as my agent under a power of attorney, so that if I become incapacitated, Peter would be authorized to make financial decisions for me. And the reason why that is important in the Medicaid or elder care planning context is because maybe I might have dementia at some point, or some other health consideration that makes me incapable of making those decisions for myself. But those decisions will still need to be made. So we want to make sure that there is someone that we trust, someone who's level-headed, someone who's smart, who can make those decisions in our absence, or substituted decisions for us if we are incapacitated. So a power of attorney is the most important planning document when we talk about elder care planning, and folks, in most cases, when we talk about estate planning.
So you have someone that's a power of attorney that could basically sign off for you, right? But what are the papers that they, power of attorney, what should they gather together? All their assets
Absolutely.
of what they owe, and then you try and figure out, as she did for us, she figures out, well, what do we need to do at the best possible avenue to take to get the best possible return? Is something like, am I saying it right?
Exactly. Because once we understand what our assets are, then we know how to plan for those assets. For example, there are certain assets that are exempt, certain assets that Medicaid doesn't count as yours. I know it sounds crazy, but for example, our home, if we are living in our home in New York, and the net equity value is under about $1 million, Medicaid says for eligibility purposes, meaning for purposes of determining whether you're eligible for Medicaid, we're not going to count your home. Now, that's not to be confused with estate recovery after you die, which is why everybody should have their house in a trust. But for eligibility purposes, Medicaid says to us, your house doesn't count if you're living there, receiving care, and the net equity value is under $1 million. Another wonderful thing about the state of New York is that in New York, your qualified retirement account, which is in payout status, does not count as an asset for determining Medicaid eligibility. Taking a step back, we know that in order to qualify for Medicaid, your assets have to be under a certain limit. That limit right now in New York is about $31,000. But when we look at that number, that resource limit, it does not include your qualified retirement account in payout status. If you reside in the 5 boroughs of New York, then if you are taking your minimum required distributions from your IRA, then the entire asset, the entire account value is considered uncountable, exempt for purposes of determining Medicaid eligibility.
How far ahead should they think about if someone needs to transfer their home to one of their children or whoever? How far in advance?
Transferring your home in almost every situation is what I would consider a no-brainer. I call it a no-brainer. Mm-hmm. Because the way you do it, if you transfer it properly, and that's a big if, but if you transfer it properly, it will not change your life at all. What do I mean by that? Transferring it to a trust that qualifies for Medicaid, but where you, as the grantor of the trust or the settlor of the trust, have the right to reside in that home for the rest of your life. You have the right to sell the home and still qualify for the Section 121A exemption, the $250,000 exemption from capital gains when you sell your principal residence. You still pay the real estate taxes, you still pay the gardener, you pay for the maintenance of the property. So, Peter, your question is when? When do we do this planning? Maybe the answer is now. Maybe we should be doing the planning now, because it doesn't hurt if you do it properly. But it has to be done properly, folks, because sometimes what people do is they'll transfer it to their children. And, well, we know there could be a lot of unintended consequences with transferring assets to your children. But if you transfer it to your children, you may lose out on the $250,000 exemption from capital gain. And you also may lose out on the basis step-up when you die. And therefore, by transferring the home to your children without retaining what's called a life estate, that may cause your children to have to bear a huge capital gains tax when you pass. So it's very, very important that when you transfer it, you do it the right way.
And if they do it in a trust for their children, and I can't believe I'm saying this, can the children kick them out?
I love this question.
This is like...
Peter, nearly every client or prospective client asks me this question. And the answer is no, if you have drafted the trust properly. The answer is no. You will have what is akin to a life estate in that property. The trust will specifically say that you, as the grantor of the trust, have the ability to live there for the rest of your life. You will have the exclusive right to live there. So again, I know I may sound like a broken record, but it is so critically important that your trust is drafted properly.
You see, that's the key. That's like a surgeon, an orthopedic surgeon, or someone that's going through quadruple bypass surgery. It has to be done perfectly. And there's no difference, because you screw up one area and it could affect everything else. Is that right?
That's 100% correct, Peter.
It's so important how much you can save and benefit from all of this by having someone like Elizabeth that can do this whole thing in a nutshell. It's a beautiful thing. Let me tell you, I want to cover something about, how about if a mom, she's failed to prepare for a power of attorney? Okay, because people make mistakes. They don't think. And I've done plenty of them. And now has dementia. Can she still sign one?
Well, the answer is, as all good lawyers say, it depends. Now, having dementia does not mean that you don't have the ability to execute documents. But the attorney is going to determine if you have the requisite capacity to execute a power of attorney. Meaning, if the individual, maybe they have a dementia diagnosis, but if they have the ability to understand the document, to understand what their rights are, what the agent's authority is or are, and if they fully understand that they have the ability to revoke the document, then they may be qualified to sign that power of attorney. But a power of attorney under the New York General Obligations Law, it's like a contract. And in order for a contract to be valid, the individual who's signing the contract has to understand all of its terms. Unfortunately, some people don't think about this far enough in advance. And they may have dementia. And it may have progressed to a point where they can no longer execute the document. And so in cases like that, unfortunately, what might have to happen is that a family member may have to petition the court to be appointed as the individual's guardian. And folks, we never want to get there. I've handled many guardianship proceedings in the Supreme Court here in New York, and they're very tough. They're emotional, they're very costly, and unfortunately, in many cases, they are contested. There might be various parties who come in and say, you want to be the guardian? No, you're not qualified to be mom's guardian. I want to be mom's guardian. And what you end up with there is a contest and a litigation. And we know in litigation, the only people that make money are the lawyers. And we don't want that. We want to avoid that. And the way to avoid that is to have a good, a fair, and a valid power of attorney. I can't stress enough
So that's number one.
the power of attorney,
That's
the
number one.
most important document.
And if you have a family that wants to do this, but there's, say, 4 children involved, are you the peacemaker? I mean, do you go, boom, eeny, meeny, miny? How does that work? Because there's going to be problems. I'm sure you've come across that, but you are the peacemaker. She's the peacemaker.
Not always, folks, not always, although I try, right? The Bible tells us we should be like Aaron,
Amen.
right? We should
Amen.
always seek peace and try to make peace between man
Right.
and his brother. But as we know, doesn't always happen. It's very important that when we execute these documents and when we do our planning, whether it's a power of attorney or whether it's a will or a healthcare proxy, that the people that we put in place, those are people who will make the right decisions. Now, that's a tall order. We don't always know who from our children or from our brothers and sisters or from our friends is going to make the right decision. But as we do this planning, we have to think about who is that person that, if put in a difficult position, would have my best interest at heart. At heart.
Yeah, there you go.
Who would have our best interest at heart? It doesn't have to be your most beautiful child or your most handsome child. It doesn't have to be your most brilliant child, but it's the one that understands what your values are. And it doesn't have to be your child at all. It could be a friend or a neighbor or perhaps your accountant. But it needs to be the individual that you know will make the right decision.
And that's the key right there. And that's how you get started, right there. And one thing you have to leave out is pride and ego. If it comes down to that on the table and you're picking the power of attorney and you got a family loaded with children, you have to keep pride and ego out and do what Elizabeth says and suggest and do what's right and what's going to benefit all of us. And it will work. It will work. And I can assure you, I have seen this with myself, and I've seen it with many other people. This is what you need to do to have things done efficiently at the time of our life when it has to be done. Okay, you don't want to end up losing so much when you can have so much. But do it and do it the right way. And she does it the right way, and it's done efficiently. I want to thank you, Elizabeth. This has been such a blessing again to have you on and to put this out there. I hope you got as much out of this as I did. God bless you. We'll see you next time.
Thank you.